The pillows are fluff thanks to Miss Emily. The couch is wide enough, join the family. It's all love while we laugh at Bert's criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Ooh, oh, please, my body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh please, the puppies need me. Oh please, my body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.
Hello, Sofa Squad. How is everybody doing? Welcome to the sofa. I hope y'all are doing well. Y'all already know. Drop a number one if you can hear me talking, so that I'm not just talking to myself all alone over here on the pretend sofa behind me on the green screen. And also, welcome all the mods. Hello, Audra. Hello, Emily. Hello, Tux. Thanks, Crystal, for the one, and Carrie, and RJB. Hey, Yvonne. Hey, Charlie. Hey, Carrie. Hey, Amy. Hey, Mama. I hope everybody's doing well. I hope everybody had a wonderful, wonderful, wonderful Wednesday. So, y'all, a couple of things we're doing tonight. You already know Donna Adelson dropped wanted to have a new trial and all that. So we're going to read through that. We're going to read through an email from Jackie, who's in the chat room, I believe. And she's been scoping everything out for us. She was at the trial, kind of giving us like insider tea, And so she was kind of like lingering around to see like if there was a grand jury going on, that type of thing, last couple of days. And so we're going to read through that. And then we're going to read through the motion and see what old Donna's saying. I have held off on reading it until here. So, pardon me, this will be my first time reading it as well. So, there you go. So, let me pull this email up real quick. And then we're going to read through that first. And then shooby-doop-doop-doop-doop. How about that? I said, there's Jackie. Okay. Oh, yeah. Okay, so Jackie ran by the courthouse to take out the tea to see like if she could spot any familiar faces of the grand jury thing to give us a vibe on like, are they talking about Wendy? Are they talking about Harvey? Are they talking about this? Are they talking about that? Okay, so there is heavy security on the north wing of the third floor, which is room 3G, the largest courtroom. There was an officer that was guarding the entrance to the room, sitting at a table checking IDs of anyone who entered the courtroom. I recognized her from the trial and was afraid she would recognize me too from being there 2 weeks ago, so I moved around a lot and avoided sitting too close by for too long. There were two other deputies routinely walking around the rotunda on the third floor too, and every time I looked up from my phone, I felt like they were staring at me. She was very doing the cognito work for us. I love it. I do appreciate you, Jackie. And then I moved down to the second floor rotunda area where you could still see some or hear voices, see people who was getting on and off the elevator. I spotted Sarah Duggan walking away from the courtroom. However, that doesn't mean much since the state attorney's offices are in that courthouse. I read the elevators up and down about 5 times to try and get, she was putting in this work, Jackie. We love you. About 5 times to try and get in with anyone coming or going to the third floor. Was able to chat with somebody working at the courthouse. I said, wow, they've got some security going on the third floor. And she responded, oh yeah, that's why I'm taking my lunch walk around the second floor. She walked past me numerous times doing laps while I was sitting on the second floor trying to catch a glimpse of the third floor. I did check the list of courtrooms and cases happening, and Judge Everett was indeed presiding over a felony case in room 3 be where Donna will be sentenced next month. I'll attach a photo. So basically, there was a grand jury in that room that was highly guarded, but honestly, it could be anything. I saw a few people enter and exit, but no one I would recognize, and I have made myself familiar with the faces of some of the people that knew Wendy in Tallahassee. I saw a few older people that appeared to be over the age of 70, and each were exited out by that female deputy at the door. Maybe this is for Harvey, I thought. There was no lunch break, as I could tell. It was individuals that being brought in and out by a deputy. I probably wasted time going. Nope, we absolutely love little info like this, even if it's like whatever, you know what I'm saying? It was paranoid that people would recognize me as the red glasses lady. So I probably won't go back, but it was fun. It reminded me of the days back in the early 90s when I followed Duran Duran around on tour and snuck into their hotels through side entrances. Absolutely love that. We love Duran Duran. And then she's talking about the thing we're going to read through today. She sent that. I greatly appreciate it. And that's it. So thank you, Jackie, for all the work you put in. And we'll see what comes of that, meaning if there's another trial, right? So there's that. And also, I think I just saw Emily drop it, but on the main channel, we have hit 150,000 subs. Couldn't have done it without any of you. Thank you very, very, very much. I greatly appreciate it. And so thank you very much. Don't forget to like and subscribe to this channel as well. We're going to try and build this one up as well. And we've got such a great community here. So thank y'all very much. And there's Jackie. Thank you, Jackie, for getting all the tea. I do appreciate it. Now, hold on one second. I got to take a sip of this before we start reading. Let's get into it. I said a shoobie. I said a doobie. I said a shoobie. Okay. Now, Dr. Barry's going to come on Sunday, and we're going to talk about unknown number. And there's that. So let me share the screen so you can see what I'm talking about. Let's see here. Oh goodness. No. Sure, we'll just go with this one. Pardon me. Okay, let's see what this is, y'all. So, defendant's motion for new trial for leave to interview and okay, let me start over. The defendant's motion for a new trial and for leave to interview jurors. So, Donna Adelson to the undersigned, it just does all that stuff. We're going to kind of get to the chunks of this, right? The big important parts. So, it does the follows. States as follows. A jury convicted Ms. Adelson as charged in the indictment on September 4, 2025. This motion is timely filed within 10 days of the rendition of the verdict pursuant to the rules that list them. Ms. Adelson requests to leave to juror number 5 and juror number 7. Ms. Adelson files this motion for new trial on the grounds: number 1, juror misconduct; number 2, verdict is contrary to the law or weight of the evidence; number 3, the court erred in the decision of any matter of law which arose during the trial; and 4, for other cause not due to Ms. Adelson's fault, she did not receive a fair and impartial trial. Okay, so now this all so far to me just sounds like standard protocol, right? I mean, you could have had the most lockdown trial, and they're going to be talking about juror misconduct this, juror misconduct that. So there's that. Now, let's go over here. Okay, so motion, and let me get my back. Motion for leave to interview jurors. In the court's preliminary instructions to the jury, the standard instruction was read, and it quotes it. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media or a website, or any other form of communication. 6. Subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. And reviewing juror number 7's TikTok account, let me scroll down here. The undersigned identified she posted on TikTok that she was selected as a juror on August 26, 2025. A flash drive with this video will be provided to the court, as the undersigned has been informed that particular TikTok was deleted by juror from her account. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. I mean, do we know? I can't remember. Has he interviewed juror number 7? Oh, hold on. Now, who's this? Oh, Esmeralda, that's what really amazing of you. Thank you so much. What a sweet gift. And you say, yay, Paul, congratulations, Emily. I hope you feel, oh, thank you so much. And yes, I hope Emily's feeling better as well. That's really sweet, Esmeralda. I really appreciate that. Has Surviving the Survivor had number 7 on? I can't remember off the top of my head. Because the whole thing about like, okay, I was chosen for jury selection. Very quickly, my non-professional, non-credential opinion is, say she did a TikTok, which I'm like, I can't believe you would do that. Oh wait, it's the Marine that has done a few interviews. Okay. If they didn't do anything during the trial, okay, if they didn't do anything to the trial, I'm like, okay, fine. If they were doing I can't imagine they were. Hey, Amy, I'll go back and watch that one because I'm just getting the numbers mixed up in my head without looking at which one's which. So anyways, let's keep going. Okay. Additionally, juror number 5 appeared on the podcast. Well, here we go. Next sentence. Juror appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Ms. Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated he obviously did not understand that during deliberations that he considered Ms. Adelson's reactions whatsoever as concerning, as her reactions are not evidence and are extrinsic or external, rather than which adheres in the verdict. 9. As a result, the undersigned seeks to interview Juror 7 concerning his consideration of Ms. Adelson's reactions to the evidence. Okay, and that's a new thing that we're entering in now, because with these jurors immediately going and doing podcasts and stuff like that and talking about all these things, the defense is very easily able to go on and say, well, they said this and they said this, and kind of go over it. And I mean, and we've seen this have to be answered in a couple of trials now. So that part to me is interesting in how this plays out in the social media that we have today, right? It's very much, of the time. So far, I haven't seen anything that was as bad as that situation. What was it with Lori's trial, where it was almost immediately after? It was like the dude made it sound like he had listened to something the day before, whatever, like that truly sounded like, So anyways, let's keep going. And again, these are just sofa speculations from my place. I'm not coming at this the perspective of somebody who's, a lawyer or a judge or anything like that. Okay, so juror misconduct. Discussion of law. 10. According to the Florida Supreme Court, potentially harmful juror misconduct is presumptively prejudicial. It lists all that stuff. A party seeking a juror interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudiced its case. It lists all the case law. It is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. Number 11. Once improper conduct or jury misconduct is established by juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. 12. If a juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in the case warrants a new trial. I mean, yeah. 2. Verdict is contrary to the law or the weight of the evidence. Discussions of law. The only avenue for judicial review of the weight of the evidence is by motion for new trial at the trial court level. It lists all that. And we're just going to skip over the case law that's listing here for the example. 15. A motion for new trial requires a trial court to evaluate whether a jury's verdict is contrary to the weight of the evidence and to act in effect as an additional juror. 16. This standard is different than the one used by a court in the ruling on a motion for a judgment of acquittal, which utilizes a sufficiency of the evidence standard. 17. Florida courts have held multiple times when considering a motion for new trial under rule, list the number. Based on a claim that the verdict is against the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. 18. The trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. She might mess around and find herself on the electric chair. She might find herself. She needs, when they sit there and they gamble and they get a new trial and then it's worse off than they started or something like that. I mean, again, I get it. This is standard protocol. Everyone's going to do this. That's why when they do these things, I'm just like, they're just going to throw everything they can at the wall to see what sticks. And I mean, and if it's warranted, right? Everybody deserves a fair trial. If it's warranted, then great. Okay. But most of the time, these are kind of like, you know, it's just, in Northwest, hey Northwest, how you doing? Northwest says, no way Judge Everett's going to say, thought about it, guilt not proven. I mean, the state did their, Georgia and team, everybody, they were amazing in this, right? I mean, just amazing. Okay, let's keep going. 18. The trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. 19. When determining the weight of the evidence, in essence, the trial court acts as a safety valve by granting a new trial where evidence is technically sufficient to prove the criminal charge, but the weight of the evidence doesn't appear to support the jury verdict. And it lists a bunch of the case law. The role of the trial judge in passing a motion for a new trial on the ground that jury verdict is contrary to weight of the evidence is to weigh all of the evidence and determine credibility of witnesses so as to act in effect as additional juror. And it lists an example. Count 1, first-degree murder. 20. At this stage, the court must make a finding that Patricia Byrd was credible before considering Miss Adelson's alleged confession to Byrd. Under no set of circumstances can Byrd be considered credible. She testified the defense investigator with whom she spoke was a white woman. Ms. Khan was obviously not white. Okay, now on this right here, I believe he's talking about the jailhouse informant. And I'm just going to say this real quick, and let me take a sip of this. I'm going to I'm going to mute you for a second. Okay, remember how, and I can't remember which juror it is, so y'all help me out here, on Surviving the Survivor, I believe it was, how they basically were saying, and I forget how he worded it, but it was something to this effect. The way he held the weight of each juror, or I'm sorry, each witness, was like, does this person benefit if she is found guilty, right? And if the person does benefit in some way, like we're going to kind of like, he had almost like a point system. Like that's going to be half of what somebody who doesn't. So for example, the way I viewed it was this. The jailhouse informants, yes, they would receive some form of benefit, but like Donna's son, Rob, there's no, you know what I'm saying? Like he's not going to benefit from her, even though I believed everybody, it just equally. But like, I really appreciated the way that he broke this down because it was like, yeah, he had a rubric. Yeah. I mean, it was like a system, right? Crafton says he had a rubric. And so I appreciated that. I was like, okay, that's how he went about this and judged things for himself or whatever. So there's that. Yeah. And Rob, for example, had nothing to, I mean, like it was, we see he has a very not tragic. I mean, it's a tragic family story. So yeah, anyways. So them saying like, oh, you know, you can't do this, you can't do that. It's not like the juror, and every juror is different, obviously. But it's like, oh, she's not credible, she's not this. To me, I'm like, look, bro, if you pulled every juror member up there and you had some scientific method for how much weight each person had, I would almost tell you that you could extract the jailhouse informants and come up with the same verdict. Just from what I saw, right? They did not, in my opinion, make or break the case. There was the bump, in my opinion, was like the biggest thing there. Okay. The biggest thing there. You didn't need jailhouse informants for that. Now, again, whether they benefited or not, I believed what they said because it sounded so on brand. Talking about a baby grand piano. That's so Donna Adelson coded. I've got a baby grand piano in it for you. Come on now. You know, it is what it is. Okay, here we go. She further testified that she told both Mr. Varnes and Ms. Khan that Miss Adelson confessed that Miss Adelson offered her financial incentives in exchange for perjured testimony. Both Mr. Varnes and Ms. Khan disputed those claims. Additionally, Ms. Khan testified she never met with Ms. Adelson. Thus, unless the court were to believe the defense counsel conveyed to Ms. Khan that Ms. Bird was to be offered money for false testimony, Ms. Bird's testimony should be disregarded completely. Okay. The same is true of Drina Bernhardt. Ms. Bernhardt's motivation to lie was and is significant. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison release reoffender, Bernhardt's credibility was significantly impacted. The only one who testified this was Miss Adelson's words rather than Miss Bernhardt was Miss Bernhardt. However, the surveillance video admitted into evidence establishes that she and Miss Adelson worked together to write the script. And again, I can't remember which juror it was that said it, but I get that they had to do that. Like, it is what it is, right? But I do not think that evidence was the clincher. Now, again, anyone's going to sit here and pick apart stuff, right? So if you felt like, oh, we can get a little loophole with what the defense did here, or, on this witness, well, of course they're going to use it. Like, that's what their job is. Okay. The theory of the state's case was that the defendant is guilty as a principal to the charge of murder because she agreed to the plan that was carried out by her son, Catherine Magbuana, Sigfrido Garcia, and Luis Rivera, and that she paid for the crime to be carried out. There's no evidence that Ms. Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed, and for that reason, the evidence is not sufficient to support her conviction as a principal to first-degree murder. Additionally, there's no evidence other the adoptive admission from Charlie Adelson's trial testimony that Miss Adelson was aware of her son's plans until September 17th, 2014. 25. Although a person can be convicted as a principal to a criminal offense based on words alone, it cites the case number, there must be a competent, substantial evidence these words were spoken in advance of the crime. A person can be convicted as a principal to a crime under section that lists the numbers, statutes, only if there is evidence that he or she committed some act or uttered some words to assist another in the commission of the crime when the crime was being carried out. 26. The elements of the crime are set out in the leading case of Staten versus State, and it lists examples here. Now, we're going to scroll down here. As acknowledged previously, intent is an operation of the mind and may be established by circumstantial evidence. There certainly is no direct evidence that Miss Adelson intended for Mr. Markel to be killed. However, there is also no circumstantial evidence that Miss Adelson wanted Mr. Markel to be killed. Even if there was, there's no evidence to establish the second element, that she did some act to assist the other person actually committing the crime. Magbuana testified that per Charlie Adelson, his parents had stopped by the residence on July 18, 2014, after Mr. Markel was murdered. However, Magbuana did not testify that Miss Adelson or her husband dropped off any money that night. In the state's expert agreed the state could not place Miss Adelson or Dr. Harvey Adelson's handsets at Charlie Adelson's residence on July 18th. Even if Miss Adelson or Dr. Harvey Adelson did stop at the residence, it would have been approximately 9 hours after Mr. Markel was shot. 27. In fact, the state's request, the court found that Miss Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid Magbuana from his own money, which he kept stapled, as confirmed by Magbuana, Ryan Fitzpatrick, and June Unchita. Charlie's testimony also included the fact that he did not tell Miss Adelson he paid Magbuana for the shooting until September 17, 2014. No evidence was presented that Miss Adelson was aware of anything other than Mr. Markel had been killed prior to September 17, 2014. The defendant and Staten drove the perpetrators to the scene of the crime, waited across the street while they were committing the crime, and then drove them away in the car. In these circumstances, the jury could legitimately infer the petitioner was a participant in the crime, and thus the Supreme Court concluded that the evidence supported the defendant's conviction as a principal. And then it lists the case law or the case citation. Affirmative acts such as these are common in prosecution under the principal statute. Writing for a unanimous court. Okay, it just goes into more of this. Okay, so we're going to skip through this. Let's get down to the chunk. this is just a bunch of stuff here. Okay, yeah. Okay, let's get down to 33 here. The state may argue that Miss Adelson's act of delivering money to her son's house sufficiently establishes what she did the day of the murder. However, nothing about delivering money after the murder could support her conviction as a principal to the murder itself. Additionally, there is no evidence of what Miss Adelson agreed to pay the killers prior to the murder. In fact, McBwana testified during the trial that the amount of payment was never addressed prior to the murder. The state may also argue that Miss Adelson necessarily provided Mr. Markel's tag number to her son, who gave it to McBwana, who then gave it to Garcia Rivera. However, there's no evidence the tag number was ever given to Charlie, let alone McBwana, Garcia, or Rivera. Even if such evidence existed, there's no evidence this was done on or even before July 18th. No evidence was admitted during trial to establish the purpose for which Miss Adelson had the tag number in her 2014 planner. Finally, with respect to the second principal instructions, there's no evidence Miss Adelson made any payment prior to the murder, or that she, rather than Charlie, promised any payment prior to the murder. At worst, even if Miss Adelson dropped off cash at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability as an accessory after the fact, but are not competent evidence as a principal to first-degree murder. So, again, with all that there, and a lot of that gets technical and whatnot. Oh, please, Amy, thanks for gifting 20 memberships. That's sweet of you. Thank you. And I'm sure everyone who received those is like, yay, Amy. So, again, one of the thing with this trial is, like, all the stuff that Donna was doing was very, and when I say slippery, I mean, obviously it was slippery, but it was clearly enough to be like, you read between the lines, you know what's going on. We know what the TV repair was. Unfortunately for Donna and Charlie, especially Charlie, okay, Donna at least had the smarts to be like, oh, son, we'll talk about it tomorrow. Okay, we'll talk about it tomorrow. You know, let's do that, son. He wouldn't leave it alone. And once it's, to me, like the vibe I got is once you've broken the we're going to talk in code vibe, then they just let it all hang out, right? It's like it just all comes out there, and like not like they're talking freely at that point, but enough to where you can guess what's going on here. Now, had she completely not talked about this stuff on the phone, here's my thing, and I guess this is a question for everybody. Do we think pretend the bump happened and they legit said nothing on the phone calls except this? Hey, I was going to come by and see you tomorrow. Okay, cool. I'll talk to you then. That's all you had on the wiretaps. Now, let's suspend here for a second where they were following them to the restaurant, right? Pretend that, like, let's take that part out, okay? Do we think that they could have had a case against them? Even, and I mean, I guess you then have to isolate all this type of stuff, but like, because it's like, well, then what about the jails informants? What about this? You know, I would question if you removed all of the phone calls and all that kind of talk, like the bump happens and they cannot show that the phone numbers went all the way down to the hitman and back up, right? Hold on 1 second. Let me get you. Yeah, it's everybody's saying without the bump, it wouldn't have been used. Yeah, hard to make a case without the bump. So see, because to me, the bump was a big thing. I guess what I'm getting at is I get where they're like, well, she didn't do this and she didn't pay this and she didn't do this. So much of this was like these, again, read between the lines. You know what's going on. You know what this is about. You know what that's about. And the phone calls sealed the deal because the bump did what it was supposed to do. The bump absolutely rattled all of them to their core. Right? Absolutely rattled them to their core, and it sent them shaking. And they went, I mean, they just told themselves, they were on the phone. What about this? What about that? What about this? What about that? You know, Charlie with his stupid, you know, it's a mic drop. Yeah, it's a mic drop moment. Yeah, oh, absolutely. You know, oh, is it a Yelp review? It's just, I mean, it's whatever. Okay, so count number 2. Conspiracy to commit first-degree murder. The state's theory on count 2 is that Miss Adelson agreed with Charlie Adelson and others to kill Mr. Markel. As was clear throughout the trial, there was no direct evidence of Ms. Adelson's involvement in the conspiracy the state proved as to Charlie Adelson, Magbuena, Rivera, and Garcia. Let me scroll down. The primary evidence against Ms. Adelson was the motive. Ms. Adelson desired to have her daughter and grandsons move to South Florida. That, to me, was very obvious. Although now, also, when you look at the other combined thing, where from the interview with Dan Markel's divorce lawyer, of them filing the thing that was going to go through on July 18th, of showing Wendy had done fraud, or whatever it was he called her, another huge incentive. So, anyways, although there was certainly evidence Ms. Adelson was not happy with the way Mr. Markel treated her daughter in the litigation process, there was no evidence Ms. Adelson said or did anything to suggest Mr. Markel be killed a year after relocation was denied and the dissolution of marriage had been settled. There's also no evidence Ms. Adelson was even aware, according to Jeff Lacoste, that Charlie Adelson looked into hiring a hitman in the summer of 2013. Skip down to here. So number 4, the undersigned asked the court to consider the evidence without the state's spin placed on it. Certainly, Ms. Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markel to change his mind about relocation, like dressing the grandchildren up in certain uniforms. I mean, that was the thing. This kind of stuff that you played there, this is not normal, bitter in-law stuff. This is like twisted stuff, okay? Like twisted, very abnormal things. That's just not the norm, right? And that's just another clincher to it. It's just all made up a part of this whole little cookie, and it crumbled down on Donna. Okay, here we go. Where is the evidence Miss Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markel be killed? There is none. The state's entire case is premised on speculation and permissible stacking of inferences and theory. Without the speculation theory and impermissible stacking of inferences, I can't say that word, there was no evidence Ms. Adelson ever agreed for Mr. Markel to be killed. But to me, like, also the vibe I got, like, maybe we didn't hear the agreement take place, but we certainly heard the after effects of it. You know, especially the way they talked to the bump, like, oh, I think it's about you and me. It's clear that they planned this without, the cops weren't onto them when they planned it, obviously, right? It hadn't happened yet. So there's no evidence of that part that they could find. But like after the fact, it was like they retroactively told on themselves with electronic evidence. Okay. The evidence of flight was not that she was fleeing to avoid prosecution, but that at that time in November 2023, she believed in her son's innocence and that if he were convicted, the state would next turn their attention to her. Rather than consciousness of guilt, that is evidence of her real fear of the witch hunt, that the witch hunt would continue. 45. The trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. Although the fancy presentations, you know what's her name wrote this up. She was just upset over that. She was like, although those fancy presentations prepared by the state might have been persuasive to the jury, Ms. Adelson asked the court to look at objectively any evidence, removing the improper stacking of inferences on which the jury's verdict is premised. So, count 3, solicitation to commit first-degree murder. The state's theory on count 3 was that Ms. Adelson convinced her son Charlie to find someone to murder Mr. Markel. 47. The charge of criminal solicitation requires evidence that the person intends for the crime to be committed and that she commands, encourages, hires, or requests another person to engage in specific conduct which could constitute the commission of the crime. As the jury instructions set out, the state must provide beyond a reasonable doubt that Donna solicited Charlie or Catherine or other persons to commit first-degree murder. Please hold. During the solicitation, Donna commanded, encouraged, hired, or requested Charles or Catherine or other persons to engage in specific conduct which would constitute the commission of first-degree murder. And then 49, the evidence admitted at trial failed to establish that Ms. Adelson asked anyone earnestly or tried to induce anyone to murder Mr. Markel. Rather, the competent substantial evidence established that when Charlie was speaking with Ms. Magbuena, Concerning Mr. Markel, he would at times make or receive calls from Miss Adelson. Ms. Magbuena did not testify to any messages Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. 51. As with the argument concerning count 1 above, the evidence may have established her involvement after the fact, and her complaining to Charlie about how Mr. Markel treated Wendy Adelson. There was simply no evidence she commanded, encouraged, hired, or requested Mr. Markel be murdered prior to the murder. 52. Common sense and the plain language of 777.042 Florida statutes requires the solicitation to be committed prior to the crime. With there being no testimony from any witnesses or any evidence admitted that Mr. Adelson had asked to murder Mr. Markel, the entire premise for her conviction on count 3 is simply speculation, and, as argued in court, an improper stacking of inferences. And for these reasons, Ms. Adelson's conviction on count 3 should be set aside and a new trial granted. 3. The court erred in a decision of matter of law which arose during the trial. 54. The court erred in denying Ms. Adelson's request to admit into evidence the complete 2014 planner and 2023 planner. During trial, the defense sought to admit the complete planners to correct the misrepresentation expected to be made by the state, which came to fruition during the state's closing argument. The state argued that Mr. Markel's tag number on the 2014 planner was evidence that Ms. Adelson provided the tag number to the shooters, despite there being no evidence this happened. Rivera testified that there were words in a photograph given to Garcia, but no evidence was offered as to what those words were. With the 2023 planner, the state argued that the planner indicated, in anticipation of fleeing the country, that Miss Adelson was selling personal items. Admission of the complete planner would have corrected the misrepresentations made by the state, as there were 39 other entries in the planner where Miss Adelson listed to sell the identical items as far back as January 2023. I mean, she was probably already pre-planning. Whatever. Okay. 58. In Curtis versus State, the court recognized that judges have a duty to admit evidence that does not fit nearly within the confines of the evidence code in order to protect the defendant's right to a fair trial. It lists all the citation numbers. As the court admitted portions of both planners, there's no question concerning the authenticity of the materials, but exclusion of the planners infringed on Miss Adelson's right to present a defense, and the evidence was important to defeat the argument that she was fleeing to avoid prosecution. Thus, the court erred in excluding the planners as evidence. 59. Part 4. For other cause not due to Miss Adelson's fault, she did not receive a fair and impartial trial. Okay, now hold on one chippy while I get a sip of water. Okay. It goes without saying that all defendants are guaranteed a fair and impartial trial under the Florida United States Constitutions. The due process of the 14th Amendment guarantees the right of the state criminal defendants to be tried by an impartial jury. The 14th Amendment incorporates the essence of the Sixth Amendment right to be tried by a panel of impartial and indifferent jurors, whose verdict must be based upon the evidence developed at the trial. As Chief Justice Warren had observed, the constitutional guarantee of due process requires the courts to safeguard against the intrusion of factors into the trial process that tend to subvert its purpose. Specifically, the courts must vigilantly guard against the atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all forms of the trial conform to the requirements of law. 61. The court explains in Schutz versus State that the presence of courtroom observers wearing uniforms, insignia, buttons, or other indicia of support for the accused, the prosecution, or the victim of the crime does not automatically constitute denial of the accused's right to a fair trial. However, there are situations where the atmosphere in the courtroom might infringe on the defendant's right to a fair trial. When such a claim is raised, a case-by-case approach is required to allow courts to consider the totality of the circumstances. A defendant claiming she was denied a fair trial must show either actual or inherent prejudice. Actual prejudice requires some indication or articulation by a juror or jurors that they were conscious of some prejudicial effect. Inherent prejudice, on the other hand, requires a showing by the defendant that there was an unacceptable risk of impermissible factors coming into play. This is a case where the cumulative effects of a number of factors constitute inherent prejudice, resulting in Ms. Adelson not receiving a fair trial. When the court would rule against the defendant on many occasions, the members of the gallery supporting the state would laugh out loud. Oh my goodness. Counsel for the defendant brought this to the attention of the court, and the court appropriately advised the gallery this is not acceptable. But they answered their question right there. The court did this on more than one occasion. However, the conduct continued throughout the trial, and the court took no action to remove those who violated the order. Remember how they kept raising their hands and saying this? I mean, obviously it's an issue and they need to, but you see how they were like laying this groundwork to be able to even like come and do this. Clearly, you don't want the court laughing at your what they do. Well, you know, in the Nick Casotis thing, that people openly laughing at him. I mean, the judge was probably laughing too, right? I mean, come on, it's insane. Okay, so yeah. When you got the whole courtroom laughing at you, it's typically not good. Not only were they laughing out loud, this is good. Videos and Not only were they laughing out loud, videos and images captured through a live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. The law doesn't require the defendant appear without any emotion. In fact, this is the case, appearing to be cold to the seriousness and evidence in the case may cause the jury to believe the defendant had no care or concern for what the victim endured. Trust me, they got that already. That was translated loud and clear from a plethora of her text messages. She didn't need to help that out at all. In fact, her fake crying, I would venture to say, made it worse. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt proceedings. She did become tearful during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. She did not speak out. She was not sobbing out loud. She was not crying out. She did need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. This impacted the decisions of the jury, resulting in Ms. Adelson not receiving a fair trial. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded that Ms. Adelson decide whether she would testify. Both counsel for Ms. Adelson as well as Ms. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence, admitted, and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial in order to make a knowing and intelligent decision in what was probably the most important decision in her life. That's what she said. It's the most important decision in my life. Harvey, what do I do? The Powerpuff's confused. Okay, this is especially significant in that state made numerous changes to the evidence during the trial. When the court recessed early September 2nd to allow counsel to meet with Ms. Adelson, we spent a great deal of time reviewing the exhibits actually admitted so that we could discuss them with Ms. Adelson. Counsel then drove to the detention center to meet with Ms. Adelson for about 2 hours, arriving around 5 p.m. Counsel did not have enough time to go through every exhibit with Ms. Adelson during this meeting. Counsel advised the court of this fact of the following day when the court inquired about Ms. Adelson's decision. 70. Not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defendant in contempt of court because they were continuing to speak to their client about this important decision she had to make, which again brought an audible derogatory response from the gallery. Oddly enough, when the state needed additional time to set up electronics for opening statements, for witness testimony, for closing arguments, and even additional time to make their closing argument, the court not only gave them additional time, he joked with the prosecution about it, thus leaving the clear impression that he favored the state in this case. Surely the decision of a defendant facing life in prison is more important than the extra time the state requested to conclude its closing argument. The defendant's request was not granted and made a huge impact of the outcome of the case. The court showed favoritism to the state at most every juncture of the trial. When the trial had delayed starting times to accommodate the state's needs, the defense was required to meet its task over the lunch breaks, thus not allowing counsel time to adequately meet the obligations of counsel for the trial, resulting in the inability to consume lunch over the break. The court sustained the objections of the state without giving the defense an opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense's request to approach. Additionally, even when the court sustained a defense objection at sidebar, when the sidebar was concluded, the court announced to the jury that the objection was overruled. During one sidebar discussion, the court asked counsel a question as counsel attempted to answer the question. Counsel was met with a scolding not to talk over the court. Counsel thereafter was prevented from answering the court's questions. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of impartiality for the state on the part of the court to not only the defense, but spectators in the gallery, the media, and those viewing the trial through the media. Fellow defense attorneys commented that they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed towards Ms. Adelson and her counsel in this case. Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led to believe he favored one outcome over another, and that was read in this case, it is not realistic that a jury can set those feelings aside. The jury clearly disregarded the instructions of the court on the other issues, and did so on this instruction as well. The totality of circumstances present during Ms. Adelson's trial establishes inherent prejudice, to wit, there was an unacceptable risk of impermissible factors coming into play. And then it goes into just, closing out the stuff or whatever. Get back up here real quick. Oh, Kimberly, thanks for becoming a member. I appreciate that. So, bam. I said, bam. Shoo-be-doo. Shoo-be-doo. Shoo-be-doo-be-doo. Shoo. Shoo-be-doo. Shoo-shoo-be. Shoo-be-doo-be-doo. Okay, so here's my thing. Do I think any of this will stick? Personally, no. Am I anybody who's credentialed to make a valid conclusion of that? No. This is just standard protocol. They have to slap this out within the first whatever days. I think it's at 10. So, can I see some of the stuff being of concern? Yeah. When people are laughing, when the judge is like, I don't think the judge did anything wrong in this. Like the whole thing about like, is she going to testify? Is she going to testify? Honey, how long have y'all had? Right? And then they're like, oh, they presented all this stuff at the thing. And blah, blah, blah. No, absolutely not. They gave you plenty of time to do this. Donna's had a very long time to review the evidence and know what the situation is, right? Even if they threw out some new stuff, there's no. And Jessica says STS and nobody was laughing in court. Yeah, Jackie, no, it won't. Jackie, did you notice anybody like laughing or doing it? Like, did you notice any of the stuff that they were doing? Because that's, again, I understand if there's a gasp from the audience. Again, look at Nick. If you were watching my coverage on the Nick Casotis trial, I mean, people are laughing. It's hard not to. You know what I mean? Like, it's hard not to laugh at his testimony. But again, it obviously can make a jury. You don't want the jury to see that. I get that. From my perspective, I wasn't there. I felt like the judge was very fair. I felt like he played along with their stuff. Donna was definitely hamming it up, and him having to be like, look, here's the thing with Donna too. Donna doesn't come off as believable. So her sitting over there doing that whole thing of, oh, God, show, dance, all See, it's like, honey, we just heard the most vile things come out of your mouth, like via evidence about, Dan. So you're gonna sit over there and like literally be whimpering in a corner because you saw his autopsy thing? No, it's so fake, so fake. Complete side note, I can't remember which juror it was being interviewed by a STS, but remember how if you watched it, he said he was like, yeah, the first day we were there, I couldn't tell the difference between who Donna and her lawyer was talking about what's her name. That was so funny. I was like, oh my God, it's not just us. Yeah, and Northwest says the defense dressed her as a little old grandma. Literally, they did. Right? Completely. Hold on one second. I'm going to drink something. So here's the thing with Donna. And again, this goes for anybody. They're going to always file this stuff. It's just standard protocol. I imagine this will all get shot down. I cannot fathom. The only things that I see that are credible, and not this specifically, and it's hard to say for each trial, the whole dynamic of jurors going on podcasts as soon as it's over with and like kind of talking all this stuff, which, hey, cool, you can, is just opening up these new doors to be picked apart. Like, well, they said that they did this. And some of it could be, I mean, if a juror goes on a podcast and they're sitting here like, yeah, I couldn't believe on day 3 when I looked up this article about it, clearly a problem, right? It's just that would be no bueno. Sorry. But the other stuff is, no, it's just, it is what it is. So we'll have to see. The old Donna show is coming to an end pretty soon, right? She's going to be sentenced soon. She's going to go off, join the ranks of her family. I mean, who knows how long she'll live? There's no telling. I don't think, looking at her when she was outside of prison and versus, I was just reading your thing. How for her being in, how she's like filled out, done this, and her mode of walking compared to like even, well, I mean, it was like, a while ago, I was going to say like the bump where she's walking around. What I'm getting at is I think her health will probably deteriorate pretty quickly, right? It's just being confined, not moving as much, not having access to her, whatever. I don't think it's going to do her well. I don't think it would do many people well. But especially at her age, I just think it would be no. So, yeah. So, there you go. How about that? Shoop-a-doop-doop-doop-doop. Now, a couple of things coming up. Like I said, this coming Sunday, and I'll post it probably tomorrow, because I'm going to go to bed as soon as I get off here. I got to get up super early. Dr. Barry's coming on. We're talking about, whatchamacallit. Oh, hush, unknown number. Now, after that, or not after that, but like maybe Thursday night, that's tomorrow night. Dr. Barry said I could use her interview with Heather, Nick Casotis' first wife from the trial. She interviewed her to kind of like watch and react to. I'm going to hold that to do here. Well, I'll do it on both channels, but we'll watch it here first. And see, kind of finish that up. So I'm excited about that. So those will be the next couple of things popping up, whatever. And then again, we have Brian Walsh coming up next month. That's what we're going to be following. And let's see here real quick. Do we have any update on Sarah Hartfield? Still no update on that. I don't know about Sarah Hartfield's trial, if we're going to be able to watch that together or not. It's up in the air if they're going to allow cameras or not. Mind you, it's, it's the 17th and it's the 29th. So we're going to have to see on that. I don't know how that will pan out. So other than that, that's kind of it. So if you do have other trials that are going on right now and you're like, hey, Paul, check this out, let me know. Drop me an email. Reporting live from my sofa at gmail.com. So that is it. So y'all, I'm going to go to bed. I'm tired. And this was fun. This was fun to read through. So yeah, I don't think anything's going to happen. But thank you for hanging out, reading through it with me. Thank you, mods. Don't forget to like and subscribe to the channel. We're trying to get this one built up and going. And thanks for getting the other channel to 150,000. I absolutely am grateful and appreciate y'all. We will close out with Slow Morrison's Ode to the Sofa. And that's it. So I love y'all. I will see you tomorrow at some point. Have a lovely, lovely, lovely evening. Thank you, mods. Thank you, squads.
The pillows are fluff thanks to Miss Emily. The couch is wide enough. Join the family. It's all love while we laugh at Perp's criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Oh, oh, please, my body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh please, the puppies need me. Oh please, my body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, 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 come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.